You signed these. Did you go over them with Mr. Parker?
Some
He went over those with you? Do you fully understand those documents?
of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Mr. Parker, you have Lloyd Calhoun.
Yeah.
Judge Walker didn't have his thing yesterday. I said, you better do that because she won't let you plead. What is that? I think they just hadn't said, you have to have the dashboard.
All kinds of new stuff's happened since he was up here, all the words I have to say. Good morning, are you Lloyd Calhoun? And Mr. Parker, will your client waive the formal reading of the indictment?
Hey, will the judge?
And we're just going in the possession case, is that correct?
That's correct, Judge, but on the, with the prior enhancement counts to make this a third degree, and just so to be candid with the court, in 2019, he also received a 5-year sentence. This same 5-year offer was made based on the underlying facts of this offense.
Okay.
What he did was pour some PCP out on the floorboard carpet of the car, which made it difficult to measure the quantification.
Okay. All right, Mr. Calhoun, in cause number 25, DCCR 1266, you're charged with the state jail felony offense of possession of a controlled substance from April 14th of 2025. And how do you plead to that charge?
Yes.
And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Listen.
That indictment further alleges that you were previously convicted of unauthorized use of a motor vehicle, a third-degree felony, May 17th of 1993. After that was final, you were convicted of possession of a controlled substance, a third-degree felony, June 3rd of 2002. And then after that, you were convicted of unlawful possession of a firearm by a felon, July 8th of 2019. And are all three of those prior convictions true?
Mhm.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? He went over those with you? Do you fully understand those documents?
Some of them.
What do you not understand?
I gotta look at it to see it again, but most of them I do.
Well, let me go over a little bit more with you. Do you understand that if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow this agreement, you can't change your mind later,
Yeah.
right? And it looks like the agreement's for 5 years in prison with a dismissal in cause number 25 DCCR 1267, which is that tampering case.
Yes.
Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true, freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of possession of a controlled substance. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Back time?
Yes.
No.
Just the time that we've had a hold on you here. So I don't know if you are serving time anywhere else or were anywhere else. Okay, so you'll get that credit. I'm going to, is it not printing?
Okay.
I'm going to hand you in just a minute, a trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're also going to be handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. You already know this because I know you have a history with a charge of this, but I'm required to read this to you. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And then I will sign a dismissal as soon as it comes through in clause number 25, DCCR 1267.
So now.
You put in the holes.
Well,
I think I probably printed it twice at least.
and this is, what I printed stuff for Pam a while ago,
Oh.
and what I gave her wasn't all of it. Apparently ran out of paper, but I didn't know.
I printed some stuff also from that other case.
Okay,
I printed one for me, several things for myself.
well, I think it's something.
Okay, all right. Here you go. You can go back with the bailiff.
Yeah.
All right, sir, you're Devon Murray. And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Murray, in cause number 26, DCCR 0346, the state's elected to proceed on the lesser included offense of robbery from January 15th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? You fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 4-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Have no contact at all, communication with the co-defendant, and that's Lugo.
Jesus Lugo.
Jesus Lugo. You understand?
No.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Murray's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty to the lesser offense of robbery freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you in the case, and then we'll come back later for sentencing. So based on all of that, Ms. Malfino, what's the state's position with regard to a reduced bond?
The state is in agreement with that, Your Honor. He does not have any criminal history to speak of other than a possession of tobacco lab. All the criminal history is really associated with his total history with that.
All right, so. He's pleading.
No, I know, but
So, what I'm going to do, Mr. Murray, based on the nature of your plea agreement, is reduce your bond in your case to $1,500. If you make that bond, it is important that you understand a condition of that bond is to have absolutely no contact or communication with Jesus Lugo. And to do everything you're supposed to, go straight to the probation department if you get released, get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. If you get arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. So it's very important if you make that bond that you get out, you do exactly what you're supposed to, go straight to probation, and then we'll see you back here at sentencing. All right, you can go back with the bailiff.
The fluorescent lights hum over a Texas courtroom. Lloyd Calhoun, a man whose criminal history spans 3 decades, unauthorized car use in '93, possession in 2002, a felon's firearm in 2019, now faces the judge for pouring liquid PCP onto a car's floor. The prosecutor admits the drug was impossible to measure. Still, a 5-year offer stands. The judge asks if Calhoun understands the waiver of appeal. The answer chills. Most of them, I don't. But no one stops. Not the lawyer, Mr. Parker, not the state. The plea is accepted as freely and voluntarily. Calhoun is sentenced to 5 years in the institutional division. He loses his right to ever own a firearm again. The court moves on. Then the atmosphere shifts. Devon Murray, younger, with no real record except a tobacco violation, stands accused of robbery. His lawyer speaks in code, stipulations I would rather not put on the record. A co-defendant named Jesus Lugo is mentioned, then vanishes, picked up by Louisiana authorities before Texas could grab him. Murray pleads to a lesser charge. He receives 4 years of deferred probation, a $1,500 fine, and a bond reduced to $1,500. The judge warns him, one arrest, one misstep, and the deal collapses. Murray nods. The bailiff leads him out.